Clerk calls the case of people versus Corey Jones. Basis. Sit down.
Good afternoon, Your Honor. Edward Dukas on behalf of Corey Jones in 1318.
From the very first second, this doesn't feel like a routine hearing. The energy is off. You have a defendant already incarcerated out of state, multiple attorneys stepping in, and a motion to withdraw right at the start. That combination alone signals instability in the defense. Here's what matters. When a case begins with confusion about representation, the entire legal process is already at risk. Because criminal defense is built on one core principle: consistent, direct attorney-client communication. Without that, everything else weakens. And notice the judge's tone. What are we doing? That's not procedural. That's concern. The court is already sensing disorganization. Now, the attorney tries to explain the situation, but listen carefully. Everything revolves around the mother, not the defendant himself. That's a problem. Legally, the attorney's obligation is to Mr. Jones only, not his family, not third parties, him. So before we even get into the charges or evidence, the real issue becomes clear. Is this case being handled properly? Or is the defendant already being left behind by his own defense?
Good afternoon, Judge James Murray, P. 5490, appearing on behalf of Mr. Jones on the subsequent matter.
All right, what are we doing?
Your Honor, today,
Your motion.
great, this is the time for my motion to withdraw. First of all, I want to apologize for inconvenience of court. If so, I talked to mom. Well, actually, I was in contact with Mr. Jones's mother for the matter that brother counsel is on now. They were saying me on such matter. In the middle of negotiations for such case, he was arraigned on this new matter. In the rush and the haste of attempting to get off that case to make sure the arraignment went successful, failed to put limited on my appearance for the arraignment purposes. And after discussions with mom, she had decided to go in a different direction. So with that being said, I would ask that my motion.
Well, but your motion says that the relationship between you and Mr. Jones broke down.
Correct.
Okay, but that's not what you just told me.
So to flesh it out more, I was speaking to Mr. Jones on behalf through his mother. His mother was the one who went through everything. His mother reached out to me. His mother kind of did all the contacts. Mr. Jones has been incarcerated in Washington so far.
I know, but I'm trying to figure out what's the basis of your motion to withdraw.
The basis of the motion is that I was engaged by Mr. Jones's mother prior to the arraignment. She does not want to proceed with me as counsel.
Why didn't you say that in the motion? I guess because all this has done is delay Mr. Jones's matter. I just
Understood, Your Honor. I do apologize for the inconvenience.
well, it's not just apologizing to me, it's Mr. Jones. I mean, he's got a right to have his matter proceed forth, and now
Now the judge shifts the focus exactly where it belongs, on the defendant. This is critical. The court makes it clear, this is not about the attorney's inconvenience, and it's not about internal confusion. It's about Mr. Jones's rights. Every defendant has a constitutional right to timely legal proceedings and effective representation, and right now, both are being compromised. What just happened here is subtle but powerful. The judge is reminding everyone in that courtroom that delays are not harmless. Every delay affects custody status, case preparation, and ultimately the outcome of the case. And look at the situation. The attorney admits confusion, incomplete communication, and now wants to withdraw. But the case has already been delayed. That creates a legal gap where no one is actively pushing the case forward. This is where accountability steps in. Judges are responsible for preventing exactly this kind of breakdown. So the real issue is no longer just the motion, it's the damage already done. A defendant sitting in custody, and his case not moving forward.
Mr. Jones, what do you want me to do? You know? My lord. Yeah. Grab that motion. Yes, Senator.
Yes.
Mr. Jurgensen, your matter, what are you doing?
Your Honor, I sort of the tail, the other case is sort of controlling. I'd be asking for an adjournment to follow that case. My case is a fleeing matter. The other matter
I'm sorry.
is that just a fleeing case?
Yeah, but you don't have to take the baby out. That's what you're trying to do. I like hearing babies more than I do attorney. You're all right. Okay. Thank you though for having that consideration. You're good.
And I believe it's a 15-year max on one of the felonies in the other matter. So I think that I don't have that report. I don't know much about it at this time.
Has the discovery been settled? I mean, where is his case at this point?
I have not received discovery on this matter.
Pardon?
I have not received discovery on this matter.
I do have the discovery in my file media. But I'm not sure.
He was arraigned on March 2nd. And so nobody's been working on his case since?
The arraignment for, let me just clarify, for the case ending in,
The one you entered an appearance on. He was arraigned on March 2nd. I'm now sitting here a month later and no discovery's been picked up. Nobody's working on his case. Counsel, that's not how law is practiced. Ever. And certainly not here in Washtenaw County. If you were going to withdraw, then you go ahead and you get the evidence.
This is a direct lesson in how legal practice is supposed to work and how it just failed here. The judge lays it out clearly. Even if an attorney plans to withdraw, they still have responsibilities. You don't just exit and leave nothing behind. You collect discovery, organize the case, and ensure the next attorney can step in without losing time. Because in criminal law, time is everything. And here, a full month has passed with no discovery picked up. That's not just a delay, that's a breakdown in the defense process. Evidence could be sitting untouched while the defendant remains in custody. Now think about the impact. A new attorney comes in, and they have to start from zero. That means more delays, more adjournments, and more time for Mr. Jones in legal uncertainty. This is exactly why the judge is stepping in so aggressively. This isn't about frustration. It's about protecting the integrity of the process. And it raises a serious question. If no one had said anything, how long would this case have stayed neglected?
At least then, when new counsel steps in, you can turn it over to him. But you don't do this way. You don't do this to Mr. Jones. Have you ever talked to Mr. Jones?
not directly.
Then why did you lie in your motion?
When I spoke to his mother, she indicated she
Do
represents.
you have a copy of your motion? Look at paragraph 2.
Okay, I'm here.
Read it out loud. What does it say?
It states that there's been a breakdown of communication between Attorney James Murray and Jones.
How is there going to be a breakdown if you never talked to him?
Your Honor, from my perspective, I was speaking to his mother. Expressed Mr. Jones's wishes. I should have outlined that in my motion after discussing that.
Meaning you should have told the truth and had full candor to the court is what you should have had.
I'm explaining exactly what happened right now on the record. I was never attempting to mislead the court. I was speaking to.
No, you did mislead this court. You are making me, when I look at this motion, it appears that what has gone on is you and Mr. Jones are having communication, and for whatever reason, there becomes this irreconcilable thing between the two of you where you can't represent him. That's not it.
If I put a
You
minute,
never talked to him. And now he's a month out from the time that he's arraigned, and you never talked to him. You shouldn't practice criminal defense anywhere. Because your primary obligation is to your client, not his family, to him. Mr. Jones, what do you want me to do? It's your case, it's your life. What do you want me to do?
What do you mean? Like, as far as what?
An attorney. I know you got Mr. Drukas on that one, but do you want him representing you? For you, Mr. Jones, I'm going to grant the motion to allow him to withdraw because he hasn't done a darn thing for you.
This is the moment where everything becomes official. The judge grants the motion to withdraw. But listen to the reasoning, not because the attorney requested it properly, but because the attorney failed the client. That statement, "He hasn't done a darn thing for you," is devastating in a courtroom. It's a direct acknowledgement that the defendant was not properly represented. And then comes the warning, don't come back into this county until you're ready to practice like you should. That's not just criticism, that's a professional reprimand in open court. This moment matters because it shows how seriously courts take attorney responsibility. Criminal defense isn't optional effort, it's a duty, and failing that duty can directly impact someone's freedom. At the same time, the judge pivots back to Mr. Jones, asking what he wants. That's important. Despite everything, the court is restoring control back to the defendant. So what you're witnessing here is both accountability and correction, removing ineffective counsel and attempting to reset the process before more damage is done.
Don't come back into this county until you're ready to practice like you should practice. Goodbye. Goodbye. I dare you to slam that door. Okay. I'm good. This Gaines, on this case, I think he stepped in or did whatever he did, but I don't think the PD was ever appointed. And I don't know. I mean, I want to get his case moving along because if you're on this other case,
I'm on the other.
because of a conflict with the PD,
Correct.
right? I'm just trying to make sure, is there going to be the same conflict? Because then we can try to skip that step. I mean, it sounds crazy, but skip that step to get somebody appointed that's going to represent him and talk to him about the case he's on.
Let me see if I can shepherd you.
Okay. Oh, bring the baby back. See, that's upset. It took the only person I liked in the courtroom out. What, are you worried that she's talking too loud? Are you? Don't really, I'm serious. Don't worry about it. If she's got something to say, well, I'm going to let her say it and we'll just all wait.
Okay.
Are they down in the back office? Because I think if they have a conflict, they have to figure out some way to do that and then get.
Typically comes.
Right, yeah, exactly, but I think what I need to do is appoint the PD first, then get the order withdrawal and appointing you, since I don't do the appointment, but, okay, tell them, are they hearing it? They probably, I don't have them on.
No, they're not.
Can you let them know that on, Mr. Jones' case that and tell him which one it is, and that Mr. Drukas has his other case. And we're not sure whether the PD has a conflict. Mr. Jones, I apologize to you. This is not the way it's supposed to happen, but.
This is one of the most important moments in the entire hearing. And it's easy to miss why. A judge apologizing directly to a defendant is not common. Courts don't typically express responsibility unless something has clearly gone wrong within the process. And here the judge is acknowledging exactly that. This situation should never have reached this point. But notice something else. Even while apologizing, the judge immediately focuses on fixing the issue. That's the role of the court, not just identifying problems, but actively correcting them. Now the discussion shifts to appointing proper counsel, dealing with potential conflicts from the public defender's office, and ensuring that Mr. Jones actually gets representation that will communicate with him and move the case forward. This is procedural recovery. The system broke down, and now the court is rebuilding it step by step. But here's the key question. How many defendants go through situations like this without a judge stepping in this strongly?
I didn't do it, but we're going to try to make it as right as we can, all right?
Based on Mr. Gaddy's look, I think we will likely have a conflict on this matter.
On this one?
Yes.
Okay, then the approval chain to appoint counsel for him. Can you do that, Ms. Gaines? Can do that? Okay, so here's what I'm gonna do. This is gonna sound really weird. But I'm going to appoint the public defender. The public defender will then have a conflict. I then need an order from the MAC office.
I can,
And maybe I don't have to wait for the paperwork. Can you ask them that if the PD has a conflict, which it looks like they do, they'll get that. Will they be appointing Mr. Drukas? Because then I can proceed with this matter and we can go and we'll just follow up on the paperwork.
Mr. Juice, wanting to make sure that discovery gets to him tomorrow.
I'd ask for the week adjournment so I can review discovery if it does come to me.
See where-
And then we can come.
Really? I just can't appoint you myself.
Yep.
And so I have to wait from a verification from them that that's what they're gonna do.
Yes.
To who?
So far.
She doesn't have an answer yet. She should have an answer already. Type in this. Judge wants to know what's taking so long. Right. Well, I think here's what I do. Since it's a PD case at this point, I'm just going to adjourn both cases out to the 9th. We'll just make sure to follow up today with all of the paperwork. Okay, on that. So I'll adjourn both cases, probable cause conference, April 9th, 2026, 9 a.m. Bond will continue in both cases. All right. Mr. Jones, you understand kind of what's going on?
Yeah.
Got it. So one of two things will happen. It's likely that there's a conflict there, and so that you'll have Mr. Drucas for both of your cases. Okay. If not, worst case scenario, you'll have Mr. Drucas, you'll have the public defender on your case. But you got an attorney that's going to represent you. Okay. All right. We'll see you next week.
But the council was wanting to send a appearance direct, so we know who to send it to tomorrow.
Right. Okay. They'll make sure. All right. Thank you.
Thank you, Your Honor.
By the end of this hearing, the situation stabilizes, but only after significant intervention from the court. The judge ensures that Mr. Jones will have representation moving forward, whether through conflict counsel or the public defender. The cases are adjourned, giving time for proper assignment and preparation. But the bigger picture here is what matters. This case highlights 3 critical issues: lack of communication, failure to act, and misleading the court. All 3 combined created a situation where a defendant's case was effectively stalled for an entire month. And without judicial intervention, that delay could have continued. What you've just seen is the system correcting itself, but only after it was pushed to the edge. It's a reminder that the legal system depends heavily on the people within it doing their jobs correctly. When they don't, the consequences fall directly on the defendant. Now the question is, do you think the judge handled this situation fairly, or should there have been even stricter consequences for the attorney? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.